Greetings, friends. This is Chris Batts, and you're listening to episode number 24 of the Future is Bright podcast. Today's episode is part one of a two-part series with Sandra Cohen, executive compensation expert and managing partner of Cohen and Buckmann in New York City. Today, we discuss negotiating the C-suite offer. Friends, this is an episode chock full of valuable career advice and insights for you. We discussed what to look for when evaluating an offer, the components of the offer, how to think about equity, and how to think about severance clauses. We discussed tips on negotiating, when to ask certain questions, and what exactly to say. We discussed if you should hire an executive compensation attorney and when. Stay till the end as Sandra shares invaluable advice on what to do if you were let go, laid off, and so much more. If you haven't already, please subscribe to this podcast and leave a review on iTunes and YouTube. A bit more about Sandra. Sandra Cohen is the co-founder and managing partner at Cohen and Buckmann, a New York-based law firm focused on executive compensation, pensions, and high-stakes employment matters. Sandra works with leaders across the professional spectrum, helping them navigate significant events in their career trajectory. Employers hire Sandra for expertise on deferred compensation, which includes Section 409 and Section 457F plans, severance and employment agreements, stock-based compensation plans, qualified retirement plans. Sandra has over 30 years' experience of employee-related advisory expertise, originally as a human resource professional for two large Fortune 500s, and subsequently as an attorney in executive compensation, which includes 6 years, first at Sullivan Cromwell, and 10 years at Osler, Hoskin, and Harcourt, LLP. She's co-author of Global Share Plans Issues for Multinational Employers and a chapter author in the very popular treatise Section 409A Handbook. She received her bachelor's degree in French from Washington University in St. Louis, her master's in organizational psychology from Columbia University, and her JD from the Yale Law School. Welcome, Sandra, to the Future is Bright podcast. It's great to have you on the show.
Thanks a lot, Chris. I'm glad to be here.
So, Sandra, let's just jump right in it. You have some amazing content, something I'm really anxious to hear more about. I work in this daily, but not to the extent that you get to negotiate on behalf of clients and with clients. Let's talk about negotiating this C-suite job offer. I know that you have this framework for conversation today. So evaluating the offer, where do we need to start first?
Well, the most common thing I hear nearly every day on negotiations is, I hate negotiating my compensation. I usually ignore it, and now I've got this new offer or I'm getting a promotion. And my clients even say, I'm a great negotiator in my job or for the business, but I can never do it for myself. And so we start from that framework with identifying the individual's points of leverage. Where do you have a job now? How much do you want this job? Those are some of the kind of key points that you might start with. Evaluating the job overall would be just both the role and then is the compensation equitable and fair for that role. Then we start in on, okay, what elements of this offer are negotiable?
And how do you begin determining what's negotiable and what's not negotiable? Is that something that, say, the candidate or your client already knows, or you have a general sense of?
Well, sometimes a candidate or a client would come to me and they've already negotiated it. And that's always a teeny little bit disappointing. I'm happy to help them anyway. I really love my job, but I always want to get involved right when there's an initial offer. Even before the offer, sometimes there's this testing out of comp salary ranges. And that's a good time to have for the individual job candidate to already have an idea, how am I going to respond to that question, where they could get advice, whether that's from a recruiter, headhunter, or from another trusted advisor, or from me as their lawyer of like, what are you going to say when they ask you what your comp expectations are? But if I'm already faced with it, I want to hire a lawyer just to look at the legal things, and I've already happy with this compensation package, I usually say there's 5 key areas of any employment contract. These are the big things that we look at first. There's the short-term cash compensation. That's salary and annual bonus. Sometimes that's all there is in an offer, and many times those kinds of offers, they don't need an attorney like me to negotiate it for them. But people don't always, especially in the C-suite, don't get paid that way with annual cash. They get long-term equity. So that would be the second thing would be long-term cash compensation, retention bonuses, or equity comp, the very material part of a lot of offers. The third thing, there might be a sign-on bonus, maybe a make-whole award for something forfeited, or an inducement award in order to cover some risk to take this job.
Yeah.
And I guess fourth, restrictive covenants. Is there a non-compete? That's an area we spend quite a bit time negotiating. And then finally, but really I think this should come first, as the lawyer or as the risk protector, the last thing would be severance protection. Is there severance in this job offer? Is it really a contract for employment, or is it at-will employment, which of course is the sort of base of any job in most U.S. states is, we're hired at will. So unless we contract for a term or contract for severance, and then you don't have any right to keep that job. And so those are the 5 things. What's negotiable? I think all of those things are negotiable, and they all have terms, especially what happens on termination to any element of that compensation.
And let's work backwards a little bit on this. So termination, gosh, we've just been through a big season of terminations. I have a lot of executives reaching out to me. Talk to me what executives should be keeping in mind, language, types of clauses, maybe following back up with you about this around making that termination a bit more palatable.
Right. Well, can I just preach the choir for a minute? I just want to say, the number one thing you need to do, everybody listening needs to find your original employment offer and save it at home, the signed one, because that is when somebody is already fired. It's hard to know where the starting place is if they're like, I don't know, it's been 10 years since I've had this job, and I don't know if I had signed a contract with severance. So please save your documents. Or send them to your attorney who can save them for you. My archives go way back. But if you're getting a job offer, I often, clients ask me the question, like, how do I ask for severance up front? That's really uncomfortable to talk about getting terminated or getting fired when I'm being hired, which is the right time to talk about it. But I acknowledge that's awkward. And this is where having a lawyer represent you can really help you. Lawyers are always looking at risk management. We're expected to. So it's not that uncomfortable for me to talk about you getting fired right when you're getting hired. And it's really, here I have 2 tips here. So the first thing, if you're doing it, if a candidate's doing it, is to let's not call it severance or getting fired. Let's talk about your commitment to this role and call it under the umbrella of risk protection or job protection.
Okay.
I'm taking a risk, taking a new role. I'm sacrificing a job I know well, where people know me. And I just want some confirmation in this contract that the company is as committed to the job as I am, or as committed to this role. What if you were to eliminate this role? And sometimes you can even talk in terms of, what if, Chris, you're going to be my manager, you made me the offer, but Chris, what if you're not there? I trust you, but we have contracts for a reason. So that's kind of the framework in which I talk about it, and asking for that commitment to the job role from them. You would say something like, I just want some risk protection that you're as committed to keeping this role as I am as I jump here, in the form of severance in this contract, if it hadn't been offered in the first place. And in the form of talking about a job well that I'm in now, sometimes people have said, well, what if I don't have a job? I'm between jobs and I can't really use that I'm secure where I am now to get severance. And then I say, no problem. You can just talk about, before I'm sacrificing other opportunities to take this job,
Nice.
I just would like to know that you're as committed to this role as I am. And then the other things the lawyer can help you is, when are the severance events? So once we've had acknowledgement that severance would be part of the offer benefits, Then we're talking about the definition of cause, and if they changed the job too much, we call good reason clauses. Would you get severance? And there's a myriad of, a whole variety of terms there, where it can be useful to have someone who knows what's market. What do these clauses usually look like?
Yeah, so helpful. What are you seeing uniquely in the market right now related to those clauses? Are you seeing companies push back because of market uncertainty, or yeah, just curious.
Well, we're talking about C-suite offers or senior executives. They usually have a lot of leverage, and the job tenure, the average job tenure for a CEO or CFO, I think is like 5 or 6 years. So it's not that awkward to be talking about severance when we know these roles change and morph. And so some of the newer things, things that I'd want to think about is, what if I'm layered over? You're hiring me as chief marketing officer, reporting to a CEO. What if you hire someone above me, and now I have to report to the chief operating officer? Should that be a severance event by itself? And employers might be like, no, if we're willing to pay you the same amount and we've diminished your role, doesn't matter. But in other terms, no, that is key, or I don't want to be co-chief marketing officer. I know some of the audience here is lawyers, and general counsel jobs, sometimes they add duties also. So you're general counsel and chief administrative officer, or in charge of HR also. So should it be discussed in advance adding to the job? That's less common. It's usually about diminishments to the duties.
Interesting.
That might result in a severance trigger. And sometimes the answer is just no, we don't do that here. The CEO doesn't have a severance contract, and so you're not going to have one. That's a little hard to get over, but one thing you might crack the door open on severance is to talk about, well, what about if there's a change in control? Just change in control severance. That way I have protection, especially in offers for the legal department where a merger might result in job cuts. They don't need two general counsels.
And that happens frequently. That's a very frequent occurrence. So fascinating. I love the levers that you can pull if you don't necessarily get everything you want. Let's go back to point 2, I believe, on equity. So the cash, I think we don't need to spend too much time there, but that equity component, can you talk to my audience about that?
Well, a lot of times executives might undervalue this equity component. They're not, if they're not as sophisticated about how the market works and how this company's stock price is going to work. But the employers spend so much time thinking about the terms of their equity awards, and they think it's really valuable. So they're offering you something really valuable when sometimes even senior executives don't really value it. The one difference would be with private company equity awards. You can't see the market price exactly. They might be telling you how much it's worth, but if you don't see the stock price every day go up and know how many shares you have, it's hard to place that value on it. And you can't pay the rent with stock options. You need to have some liquidity. And that's a very big difference in the equity award we start with. Is this a public company where the stock can, in certain windows after vesting, at least be sold for cash? Or is this a private company where the only time this equity award is going to be worth anything is if there's a big exit,
Catalyst.
Liquidity event, an IPO, or an acquisition. And so there are certain norms around public company equity awards versus private company equity awards. And I've counseled executives who are coming from a public company where they always got a small stock grant every single year. It was maybe part of their described to them as part of the bonus, but some of it's deferred into restricted stock units. But eventually, if you're there long enough, those cash out every year to you and become part of the overall comp package. Well, how do you compare that, if that's where you're coming from, to a private company, which will give you usually one sort of mega grant at hire, and then that's supposed to be beneficial economically at the exit. How do I even evaluate that?
If I may, because the past couple of years with all the SPACs and all of the equity packages dangling as carrots in front of candidates, and then with the market tanking, interest rates going up, and valuations shifting, there is a number of candidates like saying, "Is this really worth anything anymore? Am I going to stick around? How long is this going to take?" Negotiating those packages on the front end, Sandra, can you negotiate catalysts that were supposed to happen and didn't, as an event for severance or as something related to that?
Well, I have seen in private offers a liquidity window, let's call it, if there has not been an exit, an M&A, or an IPO in, say, 7 to 10 years. It's a very good question to be asking, but it's a rare company that might offer that now upfront at higher, unless they are thinking they're in this really for the long haul. So, I've advised management teams in divisions of public companies that were going to kind of get spun off, where they were getting equity in that spun off subsidiary that's not public. And that was a negotiating point, which was, well, what's going to happen if you don't ever spin us off and you've given us all these retention incentives to
Yep.
get stock in your subsidiary that
Yep.
you own 100% of? And there was a case where we negotiated liquidity windows after 5 years where we could sell this stock back to the company.
Yep.
Some of the other first things that I look at when I see an offer with equity in it, and these are a little bit very accessible for everyone, it would be the vesting schedule, which
Yep.
I might call the forfeiture schedule. Let's see, how could you lose this award?
Yeah.
That's very glass half empty of me to look first. What happens that you would forfeit this? Is there any occasion on which you could accelerate vesting, like a termination without cause or a change in control? Is this going to vest, or will you have to keep working for the buyer? And is that out of your control? So, everyone wants the big liquidity event, but like you were asking, sometimes nothing happens.
Yeah.
And this becomes a little bit of a subset of private company awards are private companies that are owned by private equity funds or venture funds, hedge funds. Those funds want their money back, so they're interested in having an exit. And they've set up management equity awards to drive that exit. And many times there's hidden terms in the contracts that sort of don't reward you, even though you're vested, if you're not there at the exit. So we look for those sneaky provisions and at least point them out to our clients, but also try to negotiate them away if our clients have the leverage. But think about this: private equity's money can live forever, but humans, we have like a lifespan and we also have a career span.
Yeah.
So, you got recruited because of this big exit with a mega award that you might have, when I'm helping my clients evaluate it, we guess how many years to exit. What's a likely high case scenario for how much is that going to be worth? What's the low case exit amount? How many years is that? Is that 4 years from now? Divide that low case number by 4, and that's your annual comp in this job. But if you had to divide that low case number by 10, it's a lot less attractive of a job.
Yeah.
And the other thing to keep in mind is, let's say the change of control does happen, an IPO. An IPO is a very different kind of liquidity event. For instance, if an IPO is planned, it is not usually a vesting event. And people are surprised. What do you mean an IPO? Don't I just cash out and leave? No, not if you're management team. You want to be able to project to the public that our management team has retention incentives that extend beyond the IPO date. But even your vested shares for management are going to be locked up for at least 180 days. So you don't cash out in the IPO when you're a member of management of a pre-IPO company. You're still stuck with this illiquid stock.
Yeah, you're even more transparent and more stuck because of that IPO. They've got you. They don't want you running off.
Yeah, yeah. And that's another difference. There's other differences between private company job offers for the C-suite and public companies, and one of them has to do with the disclosure element. Um, if you're a named executive officer at a public company, your contract is going to be disclosed to the public, and that might make a difference in how we negotiate things for you.
Again, I want to kind of come back to some market conditions that's happening right now. So valuations are waning a bit. There's some layoffs that are taking place. Would you take any other approaches or tacks to your trade in helping executives? Are you seeing certain trends around that?
Well, I guess with lower stock valuations, that's a good time to talk about stock options and get an additional grant of stock options. I mean, the price is low. An option is just a right to buy the share of stock at a fixed price at today's value. So, one question, if somebody's coming into the organization and the rest of management has options that are priced last year at a higher valuation, that could actually be a social problem internal for them if the new hire gets today's valuation and has more upside than the old guard. We also have vesting conditions sometimes that are based on performance, which is, we have a low strike price, but you're not going to vest just based on passage of time and employment service, but also on having met certain target milestones and thresholds. One of the things on equity awards that that is a important trend for private companies especially would be an extended period to exercise those options that are vested options after termination of employment.
Interesting. So that's not regulated. That's something you can negotiate in.
You can negotiate it. There are some tax rules around the term, but they're not usually hampering being able to have a period of time. There are many options say after termination of employment, this option expires after 90 days. Well, in a private company, that creates a huge liquidity squeeze.
Yeah.
Let's say that executive's being given another job offer to go somewhere else, but they have 1 million stock options that are way in the money, meaning they have embedded value. We just can't get at that value because there hasn't been a market for this stock. If the option agreement says, well, you have to exercise within 90 days, that means the executive has to come up with the strike price that was originally negotiated or was originally granted, plus pay the taxes on that exercise.
Wow.
That could be millions of dollars in a really valuable award and can really freeze an executive in place. So there are other things we can negotiate to address the liquidity problem that would come along with being forced to exercise. The thing I worry about most is if that 90 days to exercise also applies if they were terminated without cause. Now that's not their fault. They didn't quit. And now they have 90 days to exercise and pay all that taxes. You can negotiate net exercise so that the company, gives you fewer shares and pays the taxes for you. You can negotiate an extended period to exercise. But it is hard to negotiate those things on the back end. You need to sort of put them in there on the front end. I did represent a CFO of a private company that was private equity owned, and she was coming in from the outside with, there's a very smart CEO there, but they didn't have this extended period to exercise. And so they really wanted my client to come, and she had leverage for that reason. And we got a 3-year period to exercise after any type of termination. And then afterwards, the rest of the management team wanted that, and they negotiated that with their PE fund. Well, we gave it to the CFO. Now we really should have that for all of us.
So in that case, did that client pay your bill?
The employer paid the bill, yeah.
Yeah. So let's talk about that.
Yeah. Well, so that's kind of like a little secret in executive moves. is that it is very common for, at a senior level executive offer, for the employer to reimburse the legal fees to negotiate. And I tell my clients that they don't know that. I mean, I know I represent executives, but I also represent employers. And on both sides, I think it is a fair term. It benefits the employer that that executive has had somebody knowledgeable read through these terms, and feels confident and comfortable before they sign all these contracts. I think that benefits the employer. It also keeps the employer from looking petty. Yeah, we're going to save a few $1,000. And then if they do say no, me and my executive client will say, well, let's just change your salary from 3,000
include it
to 4,000, that we can just include it. So generally, I would say 80% or so of my executive clients ask for their legal fees to be paid. I'll tell you exactly what they say or what I recommend they say, how to say it. And of that 80%, I would say 75% or more say yes. But what I tell them to say, and don't say it up front, it would be after you get the offer, after there are documents, after you ask them to please send the plan, because that never comes in the first round of documents, please send the equity plan. Then I would counsel the client to say, okay, I'm going to get some tax advice on this offer or some legal advice and tax advice. Please confirm that you'll reimburse my legal fees. I understand that's customary. That's how I ask. Please confirm you'll reimburse my legal fees. I understand that's customary. And they might say, what? I never heard of that. If they had a corporate counsel, they'd be lying, like they do. That is how it happens. But it's a more senior thing. And also executives don't know when they're moving. You don't move jobs a whole lot. I had just said the very top stays 5 or 6 years, but I certainly have a lot of candidates who call me and say, I've been loyal to my company for 15, 20 years, and this is my first outside offer, and they're doing it at jumping laterally into a senior role. So how would they know? You wouldn't know unless somebody tells you or they listen to your podcasts.
Yes, exactly. Thank you, Sandra. Such amazing advice. Pulling out the secret weapon of, hey, can I do this and use that exact language? What other kind of that anecdotal tips and myths you come across that you could share with my audience?
In terms of negotiation tips, you think what to say? Well, I mentioned at the beginning, a lot of times they say, I hate negotiating. I'm really bad at it. Everybody says I'm bad at it. And I think that the first thing to do there is to acknowledge that this is genuinely difficult to do. Like, it is hard. And you've done hard things before, and you can do this, and I can coach you through it. A lot of people would say, well, what's the worst that could happen? They might say no. You got to ask. I don't really usually take that approach. I don't really think getting a no is the worst thing that they're really worried about. They're worried about maybe being embarrassed that they ask. Like, that would be embarrassing. So it can help to know exactly what to say and when to say it. And, look, it's challenging to talk about money. We all have very deep-seated values around money, perhaps coming from our family values about whether they talked about money at the dinner table or didn't. So there may be a lot of shame associated with talking about your salary or your compensation. And another taboo topic is ambition. Especially for women executives. So negotiating your big job offer is this combination of money talk and ambition all wrapped up in one, so it's very hard. And so I say, well, look, yoga is hard too, but that's why they call it practice, and we're going to practice. So you can gain confidence going into a compensation negotiation with some data, with good data about what should the market range for this job be, and there's always a range. It's a little easier to negotiate by talking about ranges, but make sure you're comfortable with the bottom of your range, because as soon as you give a range, that's going to be, the place that they start. Exactly. But getting market data is sometimes challenging. We don't know what other people make because we're not talking about it, but there is public information around that. Headhunters can be a great source of market data. I hope they would share with you what they think jobs are paying and what's a good one. So I'm always like, pick up the phone when the headhunters call, even when you're not looking, because you want to chat and share and have somebody in your resource. And also, know when it's negotiable. I would say it usually is, and many times they expect you to negotiate. I've had a client say to me before, this is a really good offer. I love it and I want to take it, but I think I'm supposed to negotiate. And what do I do? And I'm like, it's okay to just say yes. You don't actually owe it to, womankind sometimes to negotiate a higher salary, but they feel that kind of pressure. My other tip is know how decisions will be made and by whom. Try to talk to the decision maker. Now, I don't want to diss HR. Sometimes HR has a lot of control, and I'm a former HR person myself. But for most of these C-suite jobs, the decision is being made in the board or by the CEO making a recommendation to the board. And I think I just think you should be talking to the person who controls the budget for that job.
You had some advice I'd love for you to touch on about the notion of pausing. Can you explain how that is effective in negotiating?
Well, it's a skill that you need to develop like anybody else. It's very challenging to survive the pause in the conversation. That's what I was talking about. So I can give you a few more tips about what to actually say when you get an offer. People are like, Sandra, please, what words do I use? But one of the words you use is the pause. That one right there, that's very uncomfortable. And I know I'm very much a chatterbox, so this is especially difficult skill for me to learn. But the reason to pause is the other person may fill in that pause because they felt uncomfortable and give you information. So for example, the first thing you say is they're like, congratulations, we want to give you a job offer. You're going to be the general counsel and this job salary is $400,000. And whether you are happy or unhappy with $400,000, you could say, first I would say thank you. Then I would say, how did you arrive at that package? Please tell me more. And pause. And they may give you information that will be useful to you in negotiations. They may tell you, share something about internal equity. Well, this is the most we've ever paid for a general counsel, and that'd be something you'd want to know. Well, who are the peers? What's your peer group? You don't have to negotiate right then at the first moment. You can take it all away. If equity was part of the package, you can, even if you're not so happy with the salary yet, you're going to come back with more, you can jump right to the equity. Tell me about that. And with a private company, there's lots of conversations about the equity. What's it worth? When's your exit? What's it going to be worth? I have a whole article about the top 7 questions executives should ask about the private company. But when you're negotiating for your pay, now you're in the negotiation conversation, I tell people it's a little bit like you're interviewing for the job again. You have to focus on the value that you're going to that you're going to provide. Remind them a little bit of your differentiators. In between slices of, I think that package is a little light. My expectation of market would have been this job would have been 450 to 550, but tell me more about the equity, giving them a chance to tell you why this job's really worth $1 million a year and you're just missing it. But then layer that in with reminders about why they wanted to make you the offer in the first place. For example, talk about their business and show them that you get it and you have what they need. Well, I'd be really great at this because I've done it already for my prior employer, and I know you need to, whether you're prepping for IPO, if this is a legal general counsel job. I've taken companies public before. I know how hard it is with the SEC or the underwriters negotiations, and I'm going to be great at this. I just think the offer is a little bit light. And, this was my expectation, and you should get ready to give another number. But it's usually more than one conversation. And back to that pause. Yeah, let them talk, which is what you're doing to me right now, Chris, because I could just keep talking if you'd like me to.
I've learned how to shut up and let others talk. And I love pausing and negotiating. It makes people squirm. It's so much fun. And it's so valuable. It's just really valuable. And I know a lot of attorneys have that skill, but many of them don't. And especially with what you're saying about showing their value and saying, I can do this, and this is where my value. And I can see where you can help coach someone and say, or a recruiter too, but recruiters, we have a value to bring and we will fight for the candidate, but you have all this expertise I think is really critical.
Yep, yep.
So,
A lot of times I'm coaching in the background.
yeah,
Now, I'm a lawyer. It's legal counseling too, but I would call myself a coach sometimes, and I don't have to step forward facing and represent my client like you imagine the agent for the professional baseball player does.
right.
Sometimes, yes, especially if they have a lawyer, then you don't. You know, the outside counsel will talk to your the individual executive counsel, but other times I kind of educate my client. It was like, no, you're going to ask for this, and I'm going to give you all the reasons why, or you're going to
Yeah.
fill in some of the blanks, reminding about what your strengths are, and reminding them why you're great for this job.
Sandra, I know we're talking about C-suite offers.
Hmm.
Would other levels of management give you a call? And we'll get to when should we hire a lawyer question.
Right.
But are we talking director, VP, SVP, EVP? Like what level should someone be
Right.
picking up the phone?
Well, I think that you're right. It's in that sort of director, vice president level. If you're talking about a big financial institution, I know banks have 3,000 vice presidents, but somewhere where the offer itself has components of severance or equity, and it's usually not just salary and a bonus. I mean, I can help review that, give you material highlights, but it's probably not the sweet spot where you'd hire an attorney like me until a little bit later. Um, it can be useful though to just get this education about what's available. Even if you can't make changes to this job offer, you'll sort of know for next time. And I certainly have clients who hire me just for a couple of hours of advice on the offer, and we sign it as is. But then they know, okay, now I have an employment attorney sort of in my pocket if I need one, and I feel a lot more confident signing this, that there's not any gotchas, that the terms are sort of prevailing market terms, or if there are gotchas, she showed me where they are and I can live with them. So I feel more in control, and you don't have to change anything. You can take a job.
So when should a client pick up the phone and give you a call?
Well, in terms of the life cycle of a job offer, or they have, is that
Well, you had
the right way?
described after the
Yeah.
fact, but I
Oh, yeah.
imagine that's probably not the best time to give you a ring.
Well, right. Right. I mean, a lot of times they are negotiating and they want to talk to me to identify if they want to hire an attorney at all, and they're interviewing attorneys before they actually get the offer. I think that's a smart thing to do. Then you know how much you can ask about fees. You can kind of know how much to expect. You could have got that advice about when and how to ask for your fees to perhaps be reimbursed by the employer.
Mm,
Ideally, right at that stage where, I've already had the last interview, and the
yeah,
headhunter sort of said, I think you're their top choice. You're going to get an offer and you're going to get a call on Monday.
yeah.
That's when I'd like to get the call. At
Are you,
least, yeah.
yeah. Are you working with headhunters?
I do. I'm on sort of referral lists for several executive search firms where I know if their candidates ask for a recommended lawyer,
Mm,
then but my client is the individual
of course.
directly, and so usually the headhunter kind of steps back or is perhaps a conduit for information and
Okay.
offers, and sometimes I coach them on how to talk to the headhunter, who is sometimes your friend until the sale's almost made. I have this myth, Chris, you tell me if this is true or
Let's do
not,
it.
but that headhunters don't really want their clients to get employment lawyers because I guess my imagination is that they would think the employment lawyer would point out all the bad things about the offer, and then they
Hmm.
wouldn't kind of make the sale. The candidate being the product here for the sale and not really the customer. And I don't know if that's really true, but it's sort of the sense I get is they're like, we can handle this negotiation, and oh, that's all standard. That's a great offer. You should really take it.
Yeah. That's a great question. Our business is an interesting one because we have agency issues. Who are we representing? The candidate or the client? It's very similar to real estate where you got buyers and sellers, but rarely do you have the realtor closing both sides of the deal. Sometimes that happens. And so there's agency issues of who you're representing. And as you put it, is at the end of the day, is driving the deal, is the recruiter going to care as much for the candidate or just for the fee to get it done? Um, a savvy recruiter, and I can't answer your question wholesale because everyone's got different values, but a savvy recruiter that's really after sticky candidate placements and their own reputation want a happy marriage and want what the candidate wants and want what the client wants. And that's the beauty, I think, what you would bring is creating a stronger bond through a really strong offer and healthy employment agreements. You don't want a candidate going in insecure and then realizing they've got the back end of a stick related to what severance may or may not even be present. And so I think some recruiters are just there for the deal, and others are there for relationship and long-term value.
Yeah,
So
yeah. And if it's not a good match in compensation and the terms of compensation like severance, then it's not a good match, and the recruiter probably hasn't fully done their job there either. So,
exactly, and
yeah,
that's okay. you know
yeah.
so hopefully that person learns, and hopefully there's empowerment, but yeah.
So you asked about when to hire a lawyer. I kind of want to say like and when to hire a lawyer and what do they do? So one question is what's the difference between an executive compensation attorney and an employment attorney? My cousin's an employment attorney. They'll help me with this offer.
Mm,
Well, executive compensation attorneys have heavy tax knowledge around the taxation of deferred compensation. That's my favorite code section, section 409A of the code.
you're a trained
And
person.
yes, well, executive compensation attorneys have a favorite tech code
Yeah,
section. It might not be the same as mine, but that's how you know you have a good lawyer. And they know a lot about the taxation of equity awards, so that's different as you get more senior. And
yeah,
they also have a more transactional focus rather than litigation.
yeah,
So I don't sue anybody for sexual harassment or Title VII. I'm not in court. I'm not a litigator at all. I do help people with terminations as well,
yeah,
negotiating separations, but they would hire me if they have lots of equity awards to negotiate. I will subcontract out a litigator if I hear the story and think
mm,
that they
need
have
representation.
litigation claims and need an employment litigator.
Makes
But a
sense.
transactional executive comp, I'll help prepare for M&A. I'll think ahead about what's this IPO going to look like and when are you going to have liquidity. And so it does include traditional employment lawyer
Mhm.
topics like severance, termination, non-competes. I would say we overlap with employment lawyers a lot on all of those things.
Okay.
But our focus every day is these complex contracts, whether it's for our employer clients designing incentive plans that are going to work for their management team, or, we've been talking today about representing executives. And it's a challenge to hire an attorney. I know I
Yeah.
wouldn't want to do it. There's so many of them. Like just there are headhunters too, or recruit executive search firms. But representing the employee side is a very fractured legal market of solos and small firms.
Yeah.
And so it's hard to evaluate the qualifications of an attorney. I think a personal referral is probably the number one way to go. Get a referral from another kind of lawyer. Well, who does executives and who does complex contracts? And you want an experienced one. I'm sorry, more than 10 years, I guess, because they've seen some things, right? A variety of experience helps you reach a better compromise in a negotiated agreement. A more inexperienced lawyer will have their precedent and will know some choices like what's good and what's bad. They'll know things, but I feel like the experience is really going to come in to say, no, yeah, you can
Huge.
give on this point.
It's huge. It's huge. Can I ask another question, Sandra? So we've
Hmm.
kind of done a bit of a life cycle here, and I want to just come back to some advice. So let's do a scenario. C-suite executive, let's say it's a general counsel, gets notice. Maybe it's through a merger, or maybe it's just frankly being let go. what advice would you give them?
Well, first, I'm going to assume it's bad news to get let go, but it's not necessarily the case. Sometimes
This is true.
it's welcome, and there's a severance contract already in place. So that's one question: is what are the existing rights? Was there a severance plan? Has anything, if this was merger-related termination, has anything been announced in terms of retention programs? The second thing to talk to my client about is we're going to try to keep this job for as long as possible. So if they said you're fired and next Friday's your last day, we'll start thinking about, well, what else do they need from you? Are there any special projects that you can help with? And you can start with, how about October 31st? And then the severance. That's one way to get more severance, so to speak, to have more notice.
Interesting.
Without having more severance. Most of the time, the employers are going to want a release of claims in order to normalize relations and have finality, and that comes along with a severance payment, even if there wasn't a contractual right to severance. So we sort of have to evaluate whether there's any claims there, whether there's any restrictions. Of course, what happens to the equity? Do you have to exercise those stock options within 90 days? Or can you get that extended on the back end a little bit like that? From advice from me, I can have different roles. I can be active and front-facing and contact the employer. I represent Chris. I understand he's involved in a restructuring and I'd like to talk to you. I can be that lawyer, or I can be more passive and provide support from the background with issues lists and help prioritizing what's really important here.
Yeah.
I'll tell you, a lot of clients with that position, the most important thing is the health plan. I want to stay on the health plan. And I help them realize that that's not how much that's really worth money-wise compared to the severance package. And what their rights are under COBRA, their legal rights to stay on the plan and pay for it themselves or have the employer pay for it. And I'm always like, don't beg first for paid COBRA, because that's only worth about $2,000 a month. That's worth something. It's not nothing. But if they think that that's all you want, then they'll say, sure, we'll pay your COBRA for 6 months when you really wanted your bonus paid or a higher severance amount that could be worth a lot more than $2,000 a month.
Yeah. Another question that comes to mind, I just want to ask. So arbitration has been a big thing, and a lot of these terminations have all been under lock and key. There's no conversation. And I'd love to get your take, just what you're seeing. Are you participating in that? What do you know, and how do you avoid if that's even part of it?
Right. Well, so the employers will often, more frequently want to put an arbitration clause in that you agree, if we have any dispute under this contract, that you've agreed to arbitrate all your claims. The headliner there is that it makes the dispute more private. Instead of going to court, the threat of I'm going to sue you and that'll be public, that takes away that threat from the employee. I tend to think that threat is more important for lower level employees, and it's going to be at the executive level, because frankly, a lot of the executives would also like their suit and dispute with their employer to be private. So I don't say that I don't necessarily fight an arbitration clause tooth and nail in negotiation. When I'm representing an executive, we read that clause. I may show it to litigators and say, there are terms around this arbitration clause. Are those going to be enforced? That they're using certain rules, or whether discovery is allowed. And an arbitration clause can be from 3 sentences to, a page or 2 about how the arbitration is going to go. But the one thing that I might add on behalf of an executive is, okay, we'll do arbitration, but the employer's going to pay the arbitrator's fee.
Nice.
And that's actually more expensive than you would have thought, paying an arbitrator. They also make $800 or $1,000 an hour a lot of times, just like having another lawyer. You're each paying your own counsel, and now you're going to have to split the arbitration fee, or I would say no. But if you wanted me to agree to an arbitration clause, that you're going to pay for the arbitrator as a payer.
Okay, so that's super helpful. What about non-competes? That seems to be thrown out the window right now.
Oh gosh, it does. It's certainly under a lot of scrutiny. I mean, we're current to keep this conversation current in New York. We can enforce non-competes. They have to be reasonably tailored to a legitimate business interest. We have a lot of law already restricting non-competes to those things, but they're very threatening and chilling contractual provisions. The New York State Assembly recently passed a bill that bans all non-competes in New York, but it has not yet been signed by the governor. We're in August of 2023 as I'm talking, and it may be vetoed or it may be amended to make it more reasonable. Non-competes is a state-by-state provision here, and so that makes it pretty complicated. And I would say employers are scrutinizing their own contracts, and if they're well advised by their lawyers, they're thinking, do we really need all of these? How much time do we spend negotiating them? Does our legal department, are they enforcing them against middle-level people, or can we identify who really has our trade secrets, and what's the reason? Are we not protected enough? I think employers are doing that exercise now anyway, and I hope that the individual executives would result in a little more freedom of movement. I think banning non-competes is kind of a mistake, but I'm of two minds of it, because at the executive level, it's something you can offer to contract for more money. If you are one of those key people with key secrets that is legitimate business interest to keep you from working for our competitors, that could be a valuable thing that you can get paid for. And if they're banned, I don't know, it's value that should be contracted for that's sort of disappearing.
Yeah, value goes away. That's interesting. Sandra, so appreciate your time today. It's been an honor and a pleasure. Actually, one quick question. How can people find you, follow you, contact you?
Well, I'm on LinkedIn, Sandra Cohen, my middle name's with a W, or our website, cohenbuckmann.com. And Buckmann has two N's. And that's my law firm website, and my bio's on there, and you can reach me through there.
Excellent. Well, thank you again for all this invaluable advice, and we look forward to part 2 of this.
You're welcome. That was a lot of fun, Chris. Thanks for having me.